Thank you. First of all, I should say that I think I'm, at least for the first half of my talk, going to be a shameless apologist for the DOJ, so everybody stand down. I really felt strongly after the first panel that I just wanted to put a little footnote there because I wasn't on the panel. Corporations are indeed the engine of our capitalist system, I suppose, but they're also some corporations are threatening to wreck the capitalist system, and while they may create a lot of benefits for society, there are a lot of costs as well. Roscoe certainly pointed out the great harm that corporations who commit crimes can wreak on the public. In my view, then, corporate criminal liability is appropriate in appropriate circumstances. And the question is, when are those circumstances appropriate? And most people say that corporate criminal liability should be done only for deterrent purposes, and that it should only fill in where civil damages liability is not sufficient to deter corporations. And by deterring corporations, you don't want to just deter individual actors within those corporations from doing it again, because they're going to be fired, their history. By deterrence, what you want to do is force a corporation to revise its own structures, its own operating procedures, its own compensation schemes and the like, in order to prevent a recurrence of the bad behavior. And the question is, when is the corporate stigma necessary to galvanize the corporation to take those kinds of actions? And when will the sanctions, specifically organizational probation, when is that necessary over and above fines to make sure that happens? So that's just a thought. Okay. Our brief here is to talk about the DOJ's charging policy, and in particular their waiver of their policy regarding waiver of the attorney-client privilege and the work product doctrine. In my 20 years of doing criminal white-collar work, I have never seen a subject that has captured so much of the bar's attention. Basically, in the original charging instructions, you've heard about them, so I'm going to shortcut this unless you have questions. There are 10 factors that you're supposed to consider when deciding whether to charge a corporation. One of them is cooperation. In the initial policy that was put forth by Eric Holder, of all people, he noted that in some cases, cooperation will require corporations to waive the protections of the attorney-client privilege and the work product doctrine in order to turn over the kinds of materials that prosecutors are going to need to judge a corporation to be cooperative. Usually this was the result of any internal corporate investigation that was done when the wrongdoing was uncovered. And basically it gives the gives the government a big leg up, right? Because corporate counsel has inside information. They can quickly and accurately determine what things are relevant, what aren't. They can talk to employees who might well take the fifth if the government approaches them. So they have access to, they can put together, in other words, very, very quickly the relevant materials and secure the relevant statements, and the government wants that. Okay. The problem is that over time, the defense bar claims that the government has demanded waivers in every single case, or almost every case. So whenever a corporation, counsel for a corporation comes in the door, the allegation is the first thing that's said is, will you waive? And that was supposedly not the intention of the policy. Now, DOJ takes the position that their assistants have been very judicious, and that in fact this is not true. It almost doesn't matter what empirically the reality is, because defense counsel will tell you assistants don't even have to ask anymore. Defense counsel assumes that this is going to be required, and so that's part of the negotiations. All right, so this policy has brought together the ACLU and the Chamber of Commerce, the NACDL and the American Association of Corporate Counsel. I mean, it's just a strange group. And they have succeeded in interesting Congress in an act called the Attorney-Client Protection Act. It has passed the House, it's pending in the Senate, and it's not clear what's going to happen to it now. The bill would preclude the Department of Justice for requesting waivers, and it would preclude the Department of Justice for considering waivers in deciding whether or not to bring civil or criminal charges against a company. It doesn't preclude volunteered waivers, but it does preclude requests. Okay, the DOJ, eager to avoid a congressional fix, has tried mightily to revise the policy to satisfy Congress. So the progression that Roscoe showed you was, it was originally the Holder memo, then it became the Thompson memo, then it became the McNulty memo, and now it is the Phillip memo, although he, right. I'm told that Larry Thompson is desperate to have his name off this thing now that he's in private practice, but in any case, all right. So the Phillip memo, which is the last iteration, says that privilege waivers are not, and assertedly never have been, a prerequisite for credit for cooperation. A corporation may freely waive its privilege if it feels that that's in its best interest, but waiver will not be considered when deciding whether or not to charge a company. Rather, the critical determinant is whether the corporation has made available the facts necessary for a fair and responsible determination. I think counsel have accurately summarized this as basically, we don't care if you waive, just provide the relevant facts, and they leave it to the practitioners to decide how they can actually turn over the facts, which are usually embedded in work product or in attorney-client communications, without waiving the privilege. Although the Phillip memo seems to facially respond to the legislative threat, it does not, in fact, displace the legislation. So the DOJ in the Phillip memo has not agreed not to request waivers. They still can request waivers of fact work product, although they're not supposed to ask for opinion work product. As I said, it's not yet clear what's going to happen. Eric Holder has seen the light since he's been in private practice. I'm told he's outraged that assistants ask for waivers in every case, and so it's not yet clear what he's going to do. So this is the status of the controversy thus far. My thesis in this remarks is that the bar has some reason to be upset by the state of things, but it's totally misdirecting its energies. Claims that this waiver policy undermine the attorney-client privilege, the policies underlying the attorney-client privilege and the work product doctrine simply don't withstand close scrutiny. If it was a close question when the Supreme Court applied these privileges in the context of an internal corporate investigation first in Upjohn, it is no longer. In my view, the waiver policy simply does not threaten the policies underlying the privileges, and the problem then is not the waiver policy. The problem is the forces that conspire to make waivers irresistible. So let me start on the merits. First of all, the attorney-client privilege and the work product doctrine, in my view, are instrumental, not sacramental. The way that people talk about the attorney-client privilege, you'd think it was embedded in the Magna Carta. It is not. There's a reason we view privileges as necessary evils in litigation. They do impair the search for truth. And in this context, where you have what's at stake is a criminal sanction, it's really important, in my view, to get an accurate assessment of what went on and who was responsible. So the critics argue essentially that public corporations will stop doing internal corporate investigations, right, if you allow these waivers. My view is public corporations essentially have absolutely no choice but to conduct internal investigations when there is any significant allegation of corporate misfeasance. The reason is there are imperatives created by statutory, regulatory, prosecutorial, sentencing, civil liability, and corporate law pressures that require internal investigations. First of all, you need to stop the crime, right? So even if you found someone who did something wrong, you need to investigate to make sure that, for example, your earnings are not misstated into infinity, thus creating more problems. There are some statutory requirements that internal investigations be done. The organizational guidelines create a credit for having in place programs, effective compliance programs. Over time, that sentencing credit has been incorporated into the regimes of various federal regulators as well as private regulators. So, for example, a lot of agencies, when they're making determinations on civil regulatory sanctions, will ask, did you do an internal investigation? Similarly, the New York Stock Exchange, the NASD, all these private regulators also consider, when sanctioning, whether or not an internal investigation, some good faith effort to come to the bottom of things was done. Caremark, the Delaware Chancery Court, has said that directors can be liable if they don't put into place an effective reporting system. And certainly that has caught the attention of independent directors who I'm now told basically whenever there's an allegation of wrongdoing that comes up, insist on an internal investigation. So basically these internal investigations have become something of a standard operating procedure. And they in part because they work. There are a lot of, any prosecutor, and I think Alice did mention earlier today, that one of the primary considerations that prosecutors consider in declining cases is whether a credible internal investigation was done and whether there's some effort to cooperate. So in my view, corporations have compelling reasons to conduct these investigations, and the proof is in the pudding, right? They do so, if you look at the writings of practitioners, when they're not yelling and screaming about the waiver, they will say that when there are credible, serious allegations of wrongdoing, you simply have to, there are costs to doing internal investigations, but you really, on balance, you must do them. And corporations regularly do conduct these investigations despite the potential privilege waiver requests from the DOJ. And they also do so despite the lack of a selective waiver doctrine in most circuits. That is, so that means that when they turn over the materials to the DOJ, when they waive as to the DOJ, they cannot assert a privilege as to subsequent civil litigation. So they've exposed themselves to civil liability under parallel proceedings, yet they still do the internal and corporate investigations. The other argument is that the existence of the privilege, the corporate privilege, is necessary to induce agents of the company to talk to counsel. And my view is that no rational employee is going to tell corporate counsel things that they would not otherwise tell them because of the existence of the corporate privilege. Why? Because the corporation, and counsel will tell the individual this, we own the privilege. The corporation owns the privilege, you do not. Right? So what we're talking about will be privileged so long as the corporation wishes it to be so, right? But only that long. Now I'm overstating the Upjohn warning, but the warning is given that this is not your privilege to waive. So rational employees would not necessarily, I think, rely on the privilege to tell corporate counsel about all their misdeeds, because as far as they know, they can get thrown under the bus tomorrow if the corporation wishes to do so. So my view is that if the rationales underlying the attorney-client privilege and the work product doctrine are not undermined by this waiver policy, why are counsel screaming and yelling? I originally was sort of jaundiced about this. I thought, oh my gosh, here we go again, you know, a tempest in a teapot. It's corporate counsel whose ox is gored, and so, you know, this is all nonsense. But, you know, I'll tell you again, I have never seen so much attention paid to this in all my years of practice. So I tried to think more about it and to think about what could be at the bottom of this. You know, I think one could argue that in criminal cases, what you have here is what counsel is getting is a possible declination of criminal sanctions, right? And, you know, it doesn't have to be cost-free, especially if the cost, a waiver, entitles the government to make a better, more efficient judgment about who did what, right, and whether it's a crime. So one could argue that basically corporations don't have to cooperate, but if they do cooperate, there's no downside to the government telling them, you know, just what's necessary to cooperate. I think, though, that after talking to my friends in the bar, I think my predominant sense of why this dispute has engaged the passion of so many people in the bar is that these advocates, the defense bar, is genuinely outraged by the feeling that the government has stepped over the line and made it virtually impossible for them to function as defenders of corporate clients in an adversarial confrontation with the government. The waiver policy is essentially the last straw, right? It removes the adversity in any kind of criminal investigation. So my thesis turns on a circumstance that was mentioned this morning but is rarely discussed in the context of this debate. That is, corporations can't claim the Fifth Amendment privilege, right? So in this context, I believe the attorney-client privilege and the work product doctrine are critical not because they encourage self-correction or candid communication between corporate counsel and client, but rather because they serve essentially as a substitute for the Fifth Amendment in criminal investigations for two reasons. First, from a systemic point of view, the lack of a Fifth Amendment right strips the company of the only weapon it has in the pre-indictment stage to counterbalance the huge advantages of the government in investigations. The power basically to refuse to be a party to their own conviction. Second, and more concretely, these protections are the only means by which the corporation may shield from government scrutiny that which prosecutors really, really want, which is counsel's conclusions about what documents and what emails and whatever else is relevant, as well as witness statements. Demands for evidentiary and analytical material, work product, in effect, a roadmap to liability, basically forces counsel to not only lay their client open for the government, but essentially also to engineer the case against it. That's the feeling. Practitioners don't analyze this in these terms in the literature, but I think a lot of the themes are consistent. First, practitioners seem to object to a pervasive presupposition which underlies the DOJ's policy and the policies of a wide variety of federal actors, that corporations have duties not visited upon individuals to report themselves, to cooperate fully, to remedy any harm, and to aggressively take steps to prevent any future misconduct. Basically, the assumption is that when a corporation is in the crosshairs, it needs to roll over, right? And that supposition is not necessarily at least as explicit with respect to individuals. And obviously, zealous defense counsel find this assumption absolutely galling. The second theme flows from the first, and that is the bar argues that the waiver policy essentially deputizes them in a crime-fighting partnership between the government and the corporation. And they're seen as simply functionaries who are charged with exposing whatever wrongdoing has occurred, and advocates only in trying to talk the government into taking the least damaging approach, right? Regulatory sanction as opposed to criminal sanction. And they often talk about how they feel like they're junior G-men, and they hate that too, okay? So what prevents corporate counsel from just saying no to this new paradigm, right? Saying, you know where you can take your, where you can put your waiver policy. The answer is they would if they could, but they can't, so they don't. Why? Because, and here's what I think is the real nub of the case, corporations are subject to a variety of coercive circumstances that make adversary justice something of a myth, at least in this context. What is it? These same circumstances, these same coercive circumstances render irresistible requests for waivers and make it the last straw. What are these circumstances? Well, the malleable nature of the federal criminal code, with all due respect to Alice, I have to take issue. If you can't find a code section, mail and wire fraud, to hang somebody with in a corporate case, maybe not in every case, but it's certainly pretty easy. Second, and I think Andrew has it right here, the overbroad nature of corporate criminal liability standards, right? The idea that even no matter what you do as a company, no matter how effective a program you have, no matter how hard you try, you are effectively liable anytime you can identify someone within the company who did something wrong. And third, the sanctions. I mean, I think some people have talked about the overwhelming sanctions that are available. Certainly Anderson is a case in point. Now, not every company is going to die if indicted, like Anderson did. But a lot of companies that have any business with the government are going to be debarred. Any companies that are a regulated industry are going to be delicensed. And so it is a huge, huge threat. If I'm right, one might ask whether corporations, in fact, should be treated differently than individuals. That is, whether they should have, right, whether this is the correct paradigm or not. One could certainly argue that because corporations are created essentially under legislation by the state, they are in some sense a state actor, right? And that they have privileges under the law, and so they really shouldn't be able to resist governmental inquiries. That would be a perfectly legitimate view. But it's a view that really needs to be articulated and debated on the merits. I think it's a conversation worth having. It's one that some people in your question seem to indicate that you are interested in as well. As a preliminary matter, I think it's important to note that if we as a society truly believe that the adversary system, that is the clash of people with equal arms, is the best and fairest way to determine, to resolve criminal charges against individuals, it's not at all clear to me why that same system isn't the best and fairest way to address corporate criminal liability as well. Further, society has obvious and significant, if rarely articulated, interest in redressing the imbalance of power. Why? Because regardless of how one conceptualizes corporations in terms of traditional models of justice, the status quo, where corporations have neither adversarial process nor the benefits of inquisitional justice, that is the bureaucratic inquiries, it's unacceptable because not every corporation, every theory of prosecution is valid, and not every corporate subject deserves criminal sanction. And at least I believe that the system, that the framework of the system needs to be re-examined to reintroduce some sense that corporations can at least test the viability of the theories against them. Again, I don't have any problem tagging companies who did something wrong, but it strikes me that it should not be an irresistible, it shouldn't be that corporations can essentially be nailed for anything and anybody's instigation, because it doesn't serve society's interests as a whole.